Russell Laffitte's sentence hearing was today at 10 in the Charleston courthouse. I've still been concentrating on Alex, so Russell has remained a side character for me, but in the research for this, I honestly couldn't be more disgusted with this man's behavior. If birds of a feather were people, they would be Alex Murdaugh, Russell Laffitte, and Corey Fleming. Corey has his own sentence hearing coming up August 15th, 2023, so we'll be getting to his story soon. Russell's story is far too complex to cover in one episode, so today we're going to focus on one of the filings since July 27th, and there have been quite a few, and that's document 303, Government Sentencing Memorandum, and even that's a lot, because, well, you'll see. We're going to skim that today to catch up quickly with enough information to understand the squabbles over sentencing, and then I'll be adding a deep dive into Russell Laffitte to my ever-growing list of projects, so keep an eye out for that. Let's get started. This is Legal Updates with Cassidy O'Connell, where we'll break from our regular series and take a look at current filings or hearings in the cases pertaining to the illegal activities of Alex Murdaugh and friends, as we watch them meet justice one by one. This is Episode 1, Russell Laffitte's Sentencing Hearing. In the pre-sentencing report filed by Ms. Limehouse, a guideline range between 108 and 137 months was put before the court. After stealing from orphan children, a widower with 6 kids, a young man who was deaf since the age of 3 who overcame huge obstacles to make something of himself at a school for the deaf and blind, and was tragically left quadriplegic after an accident, later dying mysteriously, Russell Laffitte has the nerve to think that this sentencing request was simply too high for him, so he in turn has filed motion after motion in an attempt to avoid justice. Document number 303 was filed on July 27th, 2023. It opens by reminding us that Russell's trial lasted for weeks and that he was convicted of 6 counts of financial crimes. Afterwards, he attacked the strength of the evidence, criticized his prior counsel's representation, and challenged the court's replacement of 2 jurors during deliberations. He requested a judgment of acquittal and a new trial. In fact, he's asked for and been denied a new trial twice. The first time on December 6, 2022, which was denied on March 6, 2023, and they refiled 3 days later on March 9th, which was denied on April 10th, 2023. Paragraph 2 highlights the fact that Laffitte has objected to nearly every aspect of the PSR and reflected an unwillingness to accept any responsibility for his actions or even acknowledge the harm his actions have inflicted on the victims. There's a science to determining sentencing. We're not going to dwell too much on it, but Ms. Limehouse calculated the number and type of crimes, the total amount of money stolen, and then there are certain enhancements that should be applied in this particular case, such as preying on a vulnerable victim. So children, like the Plyler girls, like Arthur Badger's kids, and also vulnerable people like Hakeem, who had been deaf since the age of 3 and then became quadriplegic, just as he entered adulthood. Another enhancement was the abuse of a position of trust. He served as both a personal representative and a conservator to his victims and their families. He was also a high-level executive in a bank. All of these positions are considered to be positions of trust, and he did abuse them. A final enhancement is carrying out these crimes by sophisticated means, which would be the years of deceptive practices and using his position as a banker to be able to cover the crimes. Each of these enhancements add more time to sentencing because they're a deeper level of depravity. The crimes and enhancements together made this a level 31 offense, and that's how this amount of 108 to 135 months was calculated. In years, that's between 9 and 11 years and 3 months. But Russell has the nerve to think that this sentence is simply too much for him. But let's consider how long he inflicted damage on these vulnerable victims. He stole his first amount on September 14th, 2011 from the Plyler sisters. These were 2 young girls who had just lost their mom, and they spent their childhood being passed from one relative to another. That was almost 12 years ago. A few months later, he stole from Hakeem and Natasha before quickly moving on to stealing every penny from Arthur Badger. He was the widower that had 6 kids to raise because he lost his wife Donna Badger in an accident. Russell and Alex began stealing from him on February 11th, 2013, some 10 years and 6 months ago. Some of these people have not seen their justice yet. Some have been considered to be legally made whole by having their settlements reimbursed by other people. Legally, that's considered being made whole. However, there are emotional scars from the things they've gone through that will probably last their entire lifetime. They've been living in a sort of prison themselves because of Russell and Alex's crimes, but the court is supposed to feel sorry for the man who caused greater harm to people who'd already suffered unthinkable harm. And now he wants the court to grant him mercy when he had no mercy in his heart at all. I think not. Since the pre-sentencing report was put out on March 27th, there have been numerous objections from Team Laffitte, but the government has held fast to their calculations till now and continued to ask the court to overrule his objections and uphold these calculations. On page 3, we see Laffitte objects to the total loss amount, but let's take a look. I've put it in a table so it's a little easier to read at a glance. Line 1, $325,000 that was stolen settlement funds from Natasha Thomas. Line 2, $309,581.46 that was stolen settlement funds from Hakeem. Line 3, $60,000, which was improperly collected conservator fees from Hakeem. Line 4, $15,000, also improperly collected conservator fees from Hakeem's cousin, Natasha. Then the big boy, $1,325,000 that was stolen from Arthur Badger's settlement. We'll add an additional $35,000 for improperly collected personal representative funds, also from Arthur Badger. Then there was this so-called farming line of credit that was given to Alex to help pay back his illegal loans. This amount was $284,787.52. Next, we have $350,000, which was used to pay back the Chris Wilson Law Group for one of Alex's loans. Next, a $400,000 payment to help cover Alex's overdraft that was more than $367,000. And finally, $680,000 in misapplied funds in Palmetto State Bank. There's a paper trail and proof of all of these transactions. Russell has already been convicted of all of these crimes. These are undeniable. Yet, Laffitte's team is objecting to some of these things. For example, he argues that the $680,000 of Palmetto State Bank funds that was unlawfully paid to PMPED should not be included in the total loss amount. He says it's double counting with the $1,360,000 loss incurred by Arthur Badger. Now this term actual loss means the reasonably foreseeable pecuniary harm that resulted from the offense. In this offense, the $680,000 loss to Palmetto State Bank and the $1,360,000 loss to Badger were both actual losses, so they should both be included. Now the first question we need to answer is, what is this $680,000? In mid-2021, PMPED began to uncover Alex's financial crimes, one of which was Arthur Badger's stolen settlement checks. Hoping to not get caught for his share in the crime, Laffitte jumps in with the number of $680,000, and that is the amount stolen from Badger and his personal representative fee in half. But here's where he made his mistake. In his panic, he didn't think it through. This wasn't his own money. He used money from the bank's losses other than loans account, and he did it without authority or approval from the bank's board of directors. He tells the banking committee that there's an agreement between the bank and the law firm to make the client whole, but he forgets. Not everyone is like Alex. Not everyone is ready to join in the lies. Ronnie Crosby and Gene Seckinger testified that there was no such agreement. At this point, he still thinks he can cover everything up and stop any further investigation into the matter. In his communications with the bank board, he conveniently leaves out that for some of that money, he had negotiated hundreds of thousands of dollars to pay off loans he had extended to Alex from the Plyler conservatorship. Some of it was his own inflated fees for serving as personal representative, and that some of it had gone to Bank of America. So as far as Laffitte's claim that this is double counting, the government argues that there are two clear victims here. The stealing of these funds from Arthur Badger, or victim number 1, and then stealing from the bank to try to cover half of those funds, victim 2. We see their reasoning in this footnote. Pecuniary harm is actual quantifiable economic loss or economic damages. It's the opposite of non-pecuniary, which are unquantifiable, things like emotional damage, trauma, pain. Did that take place? Absolutely, both to the bank and also to Arthur Badger. Was it intentional? Also, absolutely. Laffitte was the personal representative of Arthur's wife's estate. On the disbursement sheet of her settlement, he took a huge $35,000 to fill this role. Also on the disbursement sheet, he was supposed to fund a structure for that settlement. He did not. Not only did he not do the job he paid himself handsomely to do, he stood by and helped Alex steal it all. Then, as we just learned, he stole money from his own bank to try to cover it. I don't know about you, but I clearly see two cases of pecuniary harm. In my video about Arthur Badger, we see the years of harm that came to him and his kids. And now we see the harm that came to the bank as well in Becky Laffitte's testimony, where she says, "We were out the money. I mean, you're on the hook for everything. If you get sued for this, the bank, again, is entangled in a lawsuit. And, in fact, we are entangled in a lawsuit." We'll get to more into these actions and our deep dive, but his next objection is to the government's claim that his fees were not paid for services rendered. Reading directly from this document, the defendant next argues that the personal representative and conservator fees should not be included in the total loss amount because the fees were for services rendered. We'll see about that. The record is clear. The defendant did nothing for Hakeem, Natasha, or Arthur but enable Murdoch to steal their money. Thompson testified she never met the defendant except for when Murdoch sent her to the bank to get a loan. Russell never mentioned that he was her conservator. He never talked to her about a settlement. She did not even know that the defendant had been appointed to serve as her conservator. Arthur Badger also testified that he didn't even understand that the defendant was going to be appointed as personal representative to his wife's estate. He never met him or interacted with him. In his opinion, the $35,000 never should have been paid because he simply was not his personal representative. In fact, in his own sworn testimony, Russell Laffitte established that he rendered no services to any of these clients just mentioned, although he collected tens of thousands of dollars for them. He admits he never met Hakeem and that he thinks that he met Thomas in court. He admits that he never received any funds to track or manage. He also admits that he falsified Natasha Thomas's birth date. He had to do so because she was 19 at the time, and in order to be a conservator, the person must be either a minor or otherwise unable to care for their money. At 19, she did not need a conservator. He also had to admit in a February 2022 deposition that as Donna's personal representative, he really didn't do a whole lot, yet he collected $35,000. Also in sworn testimony, he had to admit that he never managed any money for any of these clients. And the jury found that he conspired with Alex to steal the settlement funds and collected more than $110,000 for essentially no work at all. And then it makes the point, the defendant knew then, as he knows now, that he did not fulfill his duties as personal representative and conservator, nor did he render any services worthy of the fees collected. The nature of the duties of a personal representative is to protect the estate of someone who passed for their beneficiaries. Arthur was an adult, Donna's husband, and father of her children. There was no reason not to appoint him as such. Russell was appointed strictly for the purpose of stealing the settlement money. A conservator is supposed to mine the settlement money awarded to a minor to keep it safe until they're old enough to handle it. Yet Russell helped Alex to steal and spend it. He completely failed in his duties and therefore does not deserve a penny of those fees. The fact that Laffitte later tried to pay those fees back after he'd been caught is moot because of federal law code. As it states, the fact that a victim has recovered part of its loss after discovery of a fraud does not diminish a defendant's culpability for purposes of sentencing. The defendant does not get credit for repaying or attempting to repay fees he improperly collected after his crimes were detected. This is a case of too little, too late. And this is such a strong statement. Murdaugh could not have stolen from Pinckney, Thomas, or Badger had the defendant not been serving as their fiduciary. Plain and simple, Alex couldn't have stolen these funds without the help of Russell Laffitte. Yet, Russell Laffitte wants the court's mercy. Much in the way Alex is operating in his own cases right now, Laffitte's team are saying that because some of these clients have been made whole by winning civil settlements, that their losses shouldn't be included. But the government finds fault with that line of thinking by saying the goal of the loss calculation is to measure the magnitude of the crime at the time it was committed. The defendant should not get credit for the fact that Pinckney, Thomas, and Badger were made whole, and this is interesting, made whole by others, not by Alex and Russell, but made whole by others after his and Murdaugh's crimes were uncovered. He enabled Murdaugh to steal Pinckney, Thomas, and Badger settlement funds, and the PSR's loss calculation correctly takes those losses into account. His team also argues that some of the loans were paid back. Yet, a quick look diminishes this claim. A loan being created is not the same as paying something back. So this so-called paying back was simply an increase in Murdaugh's line of credit. Did that pay it back? The end of the sentence, neither the defendant nor Murdaugh paid off the $284,787.52 with their money prior to detection. It was paid down by the bank, the victim. In the fall of 2021, Murdaugh still owed over $1 million on that line of credit. This was simply not paid back. Moving on to the next point, they take issue with the enhancement that he committed these crimes using sophisticated means. However, reading from the document, the defendant and Murdaugh executed a highly complex and sophisticated scheme that spanned more than 8 years and involved the fraud and deceit of numerous vulnerable individuals, the court, law partners, and family members. The defendant and Murdaugh made misrepresentations in court documents, in part to have the defendant appointed as conservator and to hide the settlement funds from the probate court. The defendant and Murdaugh directed law firm employees to divide the stolen funds and draft the checks in a manner that allowed them to conceal the true destination of the funds. The defendant also structured transactions for Murdaugh to avoid reporting requirements. Most importantly, the defendant and Murdaugh concealed the transactions involving the stolen funds and the defendant fees by directing the law firm to make checks payable to Palmetto State Bank, an account that could not be traced to Murdaugh or the defendant. All of the checks were originally drafted to Russell Laffitte as the conservator or personal representative. Those checks could be traced, but they were voided and then drafted to Palmetto State Bank, thereby concealing the true destination of the funds. The defendant thereafter issued money orders, authorized wire transfers, and made deposits into Murdaugh's personal account. At this point, really, it's just an assault on the court's intelligence to make this objection, but let's add to it. The defendant also employed sophisticated means when he misapplied bank funds. The defendant issued an unauthorized payment of bank funds to the law firm in an attempt to conceal his scheme. That was that $680,000. He also intentionally withheld his involvement in Murdaugh's scheme. He used bank funds to pay a lawyer $350,000 at Murdaugh's direction. After the bank board began asking questions about Murdaugh's financial picture, the defendant issued a $400,000 check of bank funds and deposited into Murdaugh's account to pay down more than $367,000 in overdraft. If you didn't see that testimony during the trial, it was discovered that Alex only paid one $5 fee for that amount of overdraft, at which point the entire courtroom erupted into incredulous laughter. Next, Russell objects to the enhancement of the abuse of a position of a person of trust, but the government argues that he held a twofold position of trust, one as a bank executive and the other as either a personal representative or a conservator for his clients. By nature, these positions are considered to be held by people who have earned the capacity to be considered trustworthy enough to hold those positions. Reading again from the document, because of his position in the bank, he had the ability to extend fraudulent loans, authorize hundreds of thousands of dollars in wire transfers, and conceal the offenses. As a personal representative, the defendant was appointed by the probate court to serve in a fiduciary capacity, entrusted with the oversight and management of the victim's settlement funds. And listen to this. The defendant argues that because he never met some of the victims from whom the settlements were stolen and did not have a personal relationship with them, the enhancement does not apply. Unbelievable. Imagine that defense. I wasn't a person of trust. I didn't even know the people I stole from. Ridiculous. And the next one gets even worse. Probably the worst thing I've heard so far. In objecting to the enhancement of vulnerable victim, he argues that he didn't know Hakeem was vulnerable, first, and second, that Hakeem's money was stolen after he was dead anyway. Sweet baby Jesus, is this for real? Hakeem was a 20-year-old adult when he was rendered quadriplegic and would therefore only require the use of a conservator if he was vulnerable in some way. Does it sound any better that he served as a conservator knowing absolutely nothing about his client? Does it sound better to say, I stole from a quadriplegic, but it's okay. He was already dead. I guess I need to learn a new language because I just don't have words for this. We see the documents, the very documents that appointed Russell as conservator. He knew very well indeed why he was conservator. Did he think he was appointed conservator for a healthy 20-year-old man? Right there, in black and white, it says, I require a conservator because I'm unable to manage my property and affairs effectively due to my high-level quadriplegia, which has rendered me immobile. But now, to avoid this enhancement, he suddenly had no idea that Hakeem was quadriplegic? What did he think Hakeem died from? The footnote adds that Donna Badger's children and the Plyler sisters were all children when he helped steal their money. There's no way to argue that they were not vulnerable. Now that's just a quick walk through the government sentencing memorandum. There's so much more to explore in the saga of Russell Laffitte, and there's a mountain of files to go through. But I'm excited to share that with you soon. I just got word about the sentencing, and I'll brief you on that right now. The morning opened with attorney Emily Limehouse, who actually won the conviction against Laffitte, and there were two options that she gave for the government's recommended sentences. One was if he would admit full responsibility, waive his post-sentencing rights, then the prosecution would recommend a 72-month sentence. A second offer would require him to make full restitution to all of his victims within 60 days, but it would not require him to admit responsibility. And there would be a recommended sentence for that of 87 months. Later on in the morning, Judge Gergel called this as sophisticated a crime as he has ever seen in all his 13 years on the bench. He also called it one of the state's most notorious financial crimes. He ruled that the sentencing would be based on all of the money stolen, not just parts of it, as Russell had hoped for. Russell's lawyers fought hard with many objections, all of which Judge Gergel overruled. Then it came time for his wife, his family, and his friends to plead for mercy for him, which I don't really have the stomach to cover. In the afternoon, Russell apologized to the victim of his crimes, at one point saying that he was horrified, and he finally expressed remorse for the traumatic events that he put them through, at one point telling them, I should have taken more time to get to know you all. Then, addressing the community, he said, I am deeply sorry that I let you down. It was my honor to be the fourth generation Laffitte to get to run the bank. If I could do it over again, obviously, I would do things differently. I found it really interesting because I didn't realize that Laffitte was fourth in the line of his family to run the bank. So he's fourth in line, Alex is fourth in line. They both blew up a family dynasty, and they did it together. The judge then remarked that Russell had treated his victims like they were players on a chessboard. Sometime shortly after 3, Judge Gergel acknowledged that some of them had lost close family members, and they themselves had been survivors of terrible accidents, which left them in very vulnerable positions when they had the misfortune to encounter Murdoch and Laffitte. Hakeem's mother was present, and Hakeem is one of the ones we've spoken a lot about today. She said, I will forgive you, but I will never forget you. The Plyler girls also had a chance to speak, remarking, I was just another dollar sign to him. I felt like a burden to Russell. I felt undeserving. It really was a contrast between how his family and friends described him and how the victims saw him. She continued, "He never bothered to check on me and cut off contact as soon as I turned 18. Attorney for the Plylers, Eric Bland, said that Russell had used some of the money to build a pool for himself and to pay off high-interest loans. And with that, shortly after 4, Judge Richard Gergel sentenced Russell Laffitte to 84 months or 7 years in prison. And once that time is served, he will have 5 years of supervised release. He also has to pay $3.5 million in restitution." How do you feel about that sentencing? I would love to hear in your comments. Please share your thoughts below. Also, any questions you want me to try to find answers to in the Russell Laffitte episodes, please put those in these comments as well, and I'll try my best to answer them. Till then, this is Cassidy O'Connell saying stay well and stay tuned.